Tennessee's Attorney General speaking out on the latest setback to the Biden administration's expansion of Title IX. After a federal judge blocked the expanded rule in 6 more states, including Kentucky, Ohio, Virginia, West Virginia, Indiana, and of course there in Tennessee. It comes days after a different federal judge blocked the same expansion from taking place in 4 other states. Here to weigh in, another Attorney General, Todd Rokita of Indiana. So, sir, welcome, and thanks so much for taking the time here. Talk to me about this ruling and what this means specifically for students and how they would go about their day-to-day activities in school.
Well, thanks for having me on. I was pleased to help lead Tennessee in this effort. What it means for the students in Indiana is that, at least preliminarily, the courts have acknowledged that there are differences between boys and girls, men and women. Just like Title IX, when it was passed decades ago, understood as well that there are 2 sexes, and that the 2 sexes can't be blurred with gender identity or whatever phrase the radical left wants to use. It means that girls are going to be safe for the time being in Indiana, in their locker rooms, in their bathrooms. It means that they don't have to be offended or insulted when boys or men try to use girls' pronouns, because that won't be recognized. It won't be a violation for a school system to not follow the edicts of this radical Biden administration when it makes these types of pronouncements on them, and they don't have to worry about losing their federal funding over it, at least preliminarily.
Sure.
Which is a huge step. A lot of these cases are decided at these very early stages through things like preliminary injunctions and so forth, and that's what happened here. So we had a good day in Indiana and in several other states earlier this week.
Yeah, what you're describing, might be, to many viewers tuning in, common sense, right? Where you acknowledge the differences between boys and girls. And yet, when this Title IX ruling came down from the Department of Education under President Biden, it would have allowed, among other things, students and student athletes to use whichever bathroom or locker room or living quarters even that they identified with. Think about that with roommates in college settings. Again, on Monday, the U.S. District Judge granted that preliminary injunction, as the AG was just talking about, declaring the expansion of the rule arbitrary in the truest sense of the word. AG, what happens next? Because I know that this was supposed to go in place in August. So, maybe you've got kids, you're out for the summer, you're not even thinking about it. But in several states, obviously, across the country, these rules could go in place as your kids head back to school in the fall.
Well, ultimately, that may be true. But in Indiana and those states that joined those suit, August 1st means nothing. It just simply means that in those states, as far as the federal Title IX law goes, boys are different from girls, and that goes for their bathrooms, their pronouns. And originally, you said there were ruling when it came to the Department of Education. What they did is they promulgated rules to help interpret and define what the decades-old Title IX law was, and they tried to rewrite the law through these rules. And that's called bureaucrats trying to be lawmakers. And the court saw through that and said, no, these are major questions. There's free speech, there's compelled free speech implications with this in the terms of the pronoun use. And also what the court said is that, decades ago in the 1970s, when Title IX came about, the states couldn't possibly have thought, when they contracted, quote unquote, with the federal government for this money, right? The money comes and there's strings attached. We usually hate those. Well, Title IX is the same way. And decades ago in the 70s, no one could have contemplated that male and female also meant some gender identity confusion and blurring as well. So the court said, no, we're not going to put up with that. And now the case carries on. We've been able to have an injunction against the implementation of the rules beginning August 1st, and we'll continue to litigate the case on these successful grounds as the Department of Education tries to push back. But we're now into regular merit stage of the lawsuit. We'll see if the Department of Education continues to push.
Yes.